Good afternoon and welcome to the BRR Legal Brief, where we look at the major legal issues affecting corporate Australia. I'm David Bushby, and today we're talking about last week's Optus decision, where it had a victory in the federal court against the AFL, NRL and Telstra, giving Optus and its customers the green light to record free-to-air TV for playback over the internet. Joining us to discuss this headlining case is Truman Hoyle's Hamish Fraser. Thanks for joining us, Hamish.
Thanks for having me, David.
Hamish, if we can just kick off with this case, a lot's being said. There's talk of an appeal. There's been a well-trodden path to Canberra and backed by the lobbyists. Where are we at with this one?
David, the decision has been appealed. The NRL lodged its notice of appeal this morning. That's no surprise. I think they all said in the media they would appeal it. In fact, the judge gave leave to appeal before he even handed down his decision. So the appeal is on track, and that's the full court of the federal court. David Gallop, Andrew Demetrio, James Sutherland from Cricket Australia and a bunch of other lobbyists went to Canberra and met with the government with a view to getting a change to the law. Hopefully nothing will happen too quickly, and I think that the Attorney-General's announcement of the head of the Australian Law Reform Commission review, which was already on foot, but on Tuesday Nicola Roxon announced the head of that review, Jill McKeough from the University of Technology, Sydney. That means that I think we can now expect that the law review will happen before any legislative changes take place.
And if we can just look at the case in itself, Optus relied on an exception to the Copyright Act. Can we just look at how that applied to the Optus case and how it applies to the Optus technology?
Absolutely. The exception was contained in section 111. It's the private and domestic purposes exception, commonly referred to as the time-shifting exception, and that's the exception that allows you and I to record a TV show and watch it at a more convenient time. And what Optus did, and I think probably quite carefully and cleverly, was take the time to ensure that their service really replicated the functions of what we grew up with as a VCR, so that you press record and the show is recorded and then you watch it back at your leisure. So they've replicated that functions, albeit in a virtual sense. So what that meant was that the court found that there's in essence no real difference between personally recording a show by pressing the button or by touching a button on your screen. So by replicating that functionality, the court found that they were able to fall within that private and domestic use exception. So I think that that's a fairly common sense analysis of the virtualisation of technology in our lives. It's happening everywhere. Why shouldn't it happen for your video recorder?
Well, I mean, just talking about the video recorder and replicating that, I mean, the fact that you can actually record this and then view it within a couple of minutes, does that change this at all?
I don't think so, David. I mean, I think there was some talk in the case of the fact that there's a 2-minute delay. Now, query whether a 2-minute delay is important to people watching live sport. But that aside, I mean, if I watch a TV show, and I regularly do watch TV shows recorded on my PVR at home, I'm frequently within 2 minutes of real time. I might have just stopped to make a cup of tea or to quickly grab a drink or whatever it might be. So I don't think that 2 minutes is a big deal at all, provided that you are watching it for private and domestic purposes, and that's what the exception's about. So I don't think that 2 minutes is of any great relevance. In fact, it could be 2 seconds. Maybe it should be.
Well, I mean, the case has certainly resonated throughout Australia, but just turning to the overseas experience, assuming, of course, that in other places this sort of technology has been in place for quite some time. What's been the position there and the experience overseas?
Yeah, sure. I mean, there is products like this overseas. Of course, whether they're legal in those jurisdictions, I guess, depends on the exact language in their legislation. They mostly have very similar language, but not always identical. But there is products overseas, and in fact, in 2006, it was launched in the United States and was appealed, and a similar outcome was reached. In other words, it was acceptable, provided it was for personal use, to have a delayed broadcast. A similar decision was heard in Singapore last year, and the judge in this case referred to both of those and looked at the reasonings and adopted that same analysis, that it is the viewer, the person who's wants to consume it for their private and domestic use, that is making the recording by pressing the button. They are taking the active step, and they are taking the step not only to record it, but also to watch it. So when it is rebroadcast, if that's the word you use, and you've got to be careful using language like that, but when it is watched, it's not being rebroadcast by Optus.
Right.
The consumer has chosen to press play. So they've recorded it and then they press play. So yes, it happens overseas, and without challenge, I think it's happening in Germany, Italy, Finland, Hong Kong, at least. So yeah, it's happening elsewhere, and I think that this decision is consistent with and logical, consistent with those jurisdictions.
And Hamish, just I guess circling back to where we started at with the status of this particular case, where are we at? What implications are there, or what are the options, I should say, available both legally, commercially, and also, I guess, from a whole of industry perspective?
Sure. Look, commercially, I guess, is where the real interest is in here, that the legal path is reasonably straightforward. There'll be an appeal, the decision will be what it is, and there'll be a Law Reform Commission review, and that decision will be, and then they might make legislation. So that's a fairly well understood path, and one over which, we as the sort of general public don't have a lot of influence or say. But commercially, I think that's the really interesting thing here. Telstra have obviously felt and stated that this destroys some value in that thing they bought, and obviously the other sporting codes are concerned about that. I mentioned before about the 2-minute delay. I'm not 100% convinced that it destroys value if you can only watch it 2 minutes later. I think there's some value in live being live. So there's that element to it. But also I think, what I think Telstra's really doing here, and only Telstra really knows what it's doing, but in my view they are buying these rights with a view to capturing exclusive content. And we introduced as a nation the anti-siphoning laws to prevent exclusive content capture, and yet here we are seeing, some big corporates in Australia trying to recapture that in an online sense. I'm not entirely sure that's something from a public policy perspective that I'm comfortable with. So, from a commercial perspective, that's a very interesting outcome. I guess the other side of this is that to the extent that it takes something away from the online rights, does it not give it back to the free-to-air rights? So has the free-to-air product not just gone up in value just a little bit? I understand that there might be some ratings issues associated with that. That is, how do you measure how many people are watching it on the Optus service, unless Optus tells the ratings bureaus. But that aside, I think this is potentially a good win for the free-to-air televisions.
Well, absolutely. There's plenty of people that will be keeping a very close eye on this, and we'll have to leave it there for now. And thank you for your insights today, Hamish.
Thanks, David. Cheers.
And viewers, thank you for tuning in. We look forward to having your company next week for the BRR Legal Brief.